Yesterday, we initiated a discussion on Part 4 of the Constitution, Directive Principles of State Policy. What are the principles that the state has to keep in mind when the state is enacting laws, when the state is making policies? Those are what we call directive principles of state policy. And we have borrowed these provisions from the Constitution of Ireland. The objective of DPSP is to ensure the creation of a welfare state, is to ensure social and economic democracy. When we look at Articles 36 to 51, which come under Part 4 of the Constitution, Article 36 talks about the definition of the state, which is same as that of Article 12. But when we look at Article 37 of the Constitution, it talks about two important characteristics of DPSPs. One, these are not enforceable in a court of law. Why? We will discuss today. And second, even if they are not enforceable in a court of law, nevertheless, it shall be the duty of the state to implement them because these DPSPs are necessary for the governance of the country. Then, if these DPSPs are necessary for the governance of the country, I told you that there is some classification. Some of these DPSPs are regarded as Gandhian in character, some in liberal intellectual in character, and some in socialist character. And I gave you an assignment. Take a look at all these DPSPs and point out whether these are socialist, liberal intellectual, or Gandhian. How many amongst you did that exercise? We discussed what is the relationship between fundamental rights and directive principles of state policy. Relationship in the sense, if these DPSPs are to be implemented, because these are necessary for the governance of the country. But what if in the process of implementing these DPSPs, fundamental rights are violated? What will prevail, DPSPs or fundamental rights? For that, we looked at a case, Champak Dorai Rajan. And in this case, Supreme Court said DPSPs are inferior. Fundamental rights are superior. And to overcome this judgment, Constitution was amended. First Constitutional Amendment Act, 1951, which added Article 31 capital A, Article 31 capital B, which dealt with 9th schedule of the Constitution. Why? Because the reasoning given by the Supreme Court in Champak Dorai Rajan was that directive principles are inferior and fundamental rights are superior. You can give effect to DPSPs, you can implement DPSPs because these are essential for the governance of the country. But in the process, don't violate fundamental rights because fundamental rights, we are the protectors of fundamental rights. Specifically, two DPSPs, 39B and 39C. 39B, which says the material resources shall be distributed by the state in such a manner that it subserves common good. It leads to happiness for the maximum number of the people. And whatever economic system you want to create, whether you want to create communism, socialism, capitalism, crony capitalism, any form of ism, the operation of any economic system should not result in the concentration of wealth in fewer hands, should not result in the concentration of wealth to a common detriment. And to implement these two DPSPs, Parliament decided to enact Zamindari Abolition Act to provide for land reforms. But both these laws were struck down, saying they violate fundamental rights under Article 14, 19, and 31. 14 we have discussed. 19(1)(f) specifically talks about the fundamental right of every citizen that you can acquire property, you can dispose of your property as well. That's your fundamental right. If you are doing it on your own, that means you acquire property on your own, you dispose of property on your own, this is your natural right under Article 19. But what if state wants to acquire your land? What if state wants to acquire your property? Can the state be allowed to acquire your property? Yes. But for that, the state has to provide compensation under Article 31. And since no compensation was provided to the zamindars, since they did not voluntarily give up their lands were snatched from them, it violated Articles 14, 19, 31, and Patna High Court said these laws are unconstitutional. But then a way out was found. Article 31, capital A was added, where the Constitution said if the state wants to acquire property, take over an estate, such as a big land, it shall not be deemed to be violative of Articles 14, 19, and 31. That means although they are violative of Article 14, 19, 31, but they shall be deemed to not violate Article 14, 19, 31. Then the question was, what if this law is challenged in the court? Then ninth schedule was added to the Constitution, and any law which is placed in the ninth schedule, Constitution said there shall be no judicial review. And that is how these land reforms acts, these Zamindari abolition acts, they were saved from unconstitutionality. They were saved from the onslaught of judiciary. But matters still remain the same. DPSPs are inferior, fundamental rights are superior. Then came a time when Shrimati Indira Gandhi, as the Prime Minister, called for bank nationalization and also called for abolition of privy purse. What is abolition of privy purse? More than 562 princely states during the British India. When Indian Independence Act was passed, two different independent countries were created, India and Pakistan. What happens to these princely states? They had an option. The option was either they can choose India or they can choose Pakistan or they can stay independent as well. But this power to decide, if there is a princely state Baroda, if there is a princely state Hyderabad, if there is a princely state Junagadh, if there is a princely state Patiala, if this princely state has to decide whether to join India or Pakistan or to stay independent, who will take this decision? This decision will not be taken by the people of that princely state. This decision will be taken by the ruler. And Sardar Patel played a very important role in ensuring that majority of these princely states integrate with India, join the Union of India. And when you have to ask somebody to join you, you also have to give up something. That's part of negotiation. You can't have it all. You have to have give and take. And Sardar Patel told them, your bungalows, your palaces remain with you. Your diamonds, your pearls, your vintage cars remain with you. All your jewelry, all the money that you have remains with you. On top of that, we will give you a privy purse. It's like no questions asked money. Do whatever you want to do with this money. This is something that we will guarantee you, we will provide you every single year. All you have to do, give up your sovereignty. Merge with the Union of India. And in response to that, we will give you a privy purse, which will be a percentage of your annual revenue. That means if this is a princely state, what was the annual revenue of that princely state? A percentage of that will be given to you as part of privy purse. which means for the ruler of Hyderabad, who was known as the Nizam, privy purse was 73 lakhs a year. The ruler of a smaller princely state was given 62 rupees, and some books say was given 78 rupees. So it depends upon what was the annual revenue of that princely state. A particular percentage of that would be given to you as part of privy purse. No questions asked. Do whatever you want to do with this money. We won't question it. That is our constitutional guarantee, and that is how it came to be mentioned in the constitution itself. Privy purse. Indira Gandhi did not like this concept. Why? For a variety of reasons. She claims that when we are a democracy, when we are a republic, what is the need to provide princes a money by the state? And she was also surprised in the sense that there were the rulers in Jaipur, in today's Rajasthan, who would take this privy purse, who would take this money from the government, but use this money to contest elections against the Congress party, to fund candidates contesting elections against Indira Gandhi. And Indira Gandhi decided, Parliament, come together, let's abolish this privy purse. Not just this, banks were nationalized. What do we mean by nationalization of banks? For example, we have HDFC Bank, we have ICICI Bank, we have Kotak Mahindra Bank. These are private banks. What if tomorrow the government wants to take over these banks? These banks would be converted from private banks to public banks. That is what we call nationalization of banks. The year was 1969. Srimati Indira Gandhi decided that 14 banks should be nationalized. Why? She said, we want to implement a welfare state. Our economic system should be operated in such a manner that it should not result in the concentration of wealth in fewer hands. But what these private banks are doing, they give credit to their own people. They give credit to the wealthy, to the rich sections of the society. They deprive poor people of the credit. They don't give them loans. And ultimately, there is this circulation of wealth which is taking place. Rich people distribute wealth amongst themselves. Poor remain poorer. And what we will do, we will nationalize these banks. And both these decisions, abolition of privy purse, bank nationalization, was challenged in the court. And there was one common lawyer who fought against the government, Nani Palkhiwala. And we will discuss him in detail when we will discuss Keshavananda Bharti judgment. Both these decisions of the government were struck down by the court. Court said this is unconstitutional. Why? Because even if you are giving effect to fundamental directive principles, but thereby you are violating fundamental rights. On bank nationalization case specifically, the government had given and offered compensation. So it's not that the government had acquired these banks without giving them anything in return. The government did provide them compensation. And that compensation was in the form of bonds. And these bonds shall mature after 10 years. Government said, we will give you bonds. These bonds would get matured after 10 years, after which you can encash the money. And that is how we will provide you compensation. When the matter reached the court, the government attorney general told the court that, see, we have acquired their property, but we have provided them compensation as well. When we have provided them compensation as well, that means this compensation is in the form of the bonds. The court said, yes, you have provided compensation, but when you pay compensation in the form of bonds that will mature after 10 years, this is not a fair compensation. The very requirement under Article 31 is that when the state acquires a state, acquires property, takes over the management of any company, for that the compensation has to be provided, and that compensation has to be fair. Giving them bonds which will mature after 10 years is not a fair compensation, and on that ground it violates Article 31. This is unconstitutional. Indira Gandhi said, enough is enough. What we will do? Let's amend the constitution. Let's add Article 31 capital C to the Constitution. 25th Constitutional Amendment Act. (1971). And what did this 31 capital C say? If the Parliament wants to enact a law, because where is the problem? The problem is when the government wants to give shape, give effect to these two directive principles, 39B and 39C. 39B, that material resources should be distributed so that it leads to happiness for the maximum number of the people. It leads to common good. And any operation, any economic system that you operate should not result in the concentration of wealth in fewer hands. These were the two most important directive principles that whenever government wanted to implement, the court would come into the picture and say this is unconstitutional because you're violating Article 14, 1931. Although there existed a ninth schedule, and whenever a law is placed in ninth schedule, it gets immunity from judicial review. No judicial review takes place. But there was an assumption that laws related to land, laws related to estates, Zamindari Abolition, Land Reforms Act, such laws would be placed in ninth schedule. But here we are talking about privy purses. Here we are talking about banks and their nationalization. And here we are talking about giving impact to Article 39B and 39C. So that tomorrow there is no problem whatsoever. We want to end this fight once and for all because the court is saying DPSPs are inferior, fundamental rights are superior. Shrimati Indira Gandhi said, don't worry, we will ensure that Constitution recognizes the importance of DPSPs. Constitution recognizes the superiority of DPSPs. Constitutional amendment said, Article 31 capital C, if the Parliament wants to enact a law, and through this law, it wants to give effect to Articles 39B and 39C. These are two DPSPs. Even if this law violates Article 14, 19 and 31, merely on this ground, the law shall not be declared as unconstitutional. Further, no judicial review. Which means such a law shall not be challenged before the judiciary. What the Parliament is now saying, adding another article, 31 capital C to the Constitution, saying if Parliament wants to give effect, implement two DPSPs, 39B and 39C, even if this law violates Article 14, 1931, merely on this ground, the law should not be declared as unconstitutional. That means the law can be declared unconstitutional on some other grounds. Other grounds, other than Article 14, 1931. And further, this law cannot be challenged on the ground that it violates Article 14, 1931. which means for the first time, two DPSPs were given superiority over three fundamental rights. Matter went to the court. Keshavananda Bharti, 1973. Supreme Court said Article 31 capital C is constitutional. There is no problem with Article 31 capital C. Just that when you say there shall be no judicial review, that is something that we don't agree with, because any law passed by the parliament can be reviewed by the judiciary. Said okay. This was 1973. And in 1975, emergency was imposed, and in 1976, Constitution was amended again. 42nd Constitutional Amendment Act 1976. And in this amendment, Article 31 capital C was amended again. If the parliament wants to enact a law to give effect to one or more DPSPs, even if this law violates fundamental rights under Article 14, 19, and 31, no problem. Are DPSPs superior or inferior? Champak Dore Rajan, Supreme Court says DPSPs are inferior, fundamental rights are superior. Now, to overcome this judgment, Constitution was amended. 31 capital A was added, 31 capital B was added, 9th schedule was added, which basically said if the state wants to acquire land, estate, take over the management of a factory, even if it violates Article 14, 19, and 31, there should be no issue. Because we shall declare that when the state acquires land, estate, takes over the management of the factory, it shall not be deemed as violation of 14, 19, 31. And any law which is placed in 9th schedule, there will be no judicial review. Even then, the situation remains the same. DPSPs are inferior, fundamental rights are superior. Then came a time when bank nationalization, bank nationalization, privy purse abolition, it was declared unconstitutional by the judiciary, saying it violates fundamental rights, even if you are giving effect to DPSPs. So DPSPs and their inferior status and fundamental rights and their superior status, it was always categorically stated by the judiciary, which was unacceptable to Indira Gandhi. She said people are so much fixated with their rights that they don't understand they have duties towards the state. And that is how in 1976, a chapter on fundamental duties was added to the Constitution, which originally was not part of the Constitution, which we will discuss. So she wanted Constitution to explicitly mention that there are DPSPs which are superior to that of fundamental rights. She got the parliament together, please come, let's amend the Constitution. 31 capital C was added. And 31 capital C said, when parliament wants to enact a law to give effect, to give shape to DPSPs under 39B and 39C, even if this law violates 14, 19, 31, no problem. And this law cannot be even challenged on the grounds that this law violates 14, 19, 31. Matter went to the court. In Keshavananda Bharti case, Supreme Court said, you're right, can happen. You want to give superiority to two DPSPs over three fundamental rights? We have no problem whatsoever. But we have a problem when you say that we can't question this law. Nobody can question this law before us. This is something that we will not accept. We will not digest. Emergency was imposed. Constitution was amended again. So in 1971, if two DPSPs were given superiority over three fundamental rights. Now in 1976, Parliament is saying if we want to give effect to one or any DPSP, that means now all DPSPs. Previously, two DPSPs were given superiority over three fundamental rights. Now Parliament is giving superiority to all DPSPs over three fundamental rights, 14, 19, 31. But even this amendment was challenged in the court. Minerva Mills, 1980, where Supreme Court said judicial review is part of the basic structure of the Constitution. And court further said, relationship or balance between DPSPs and fundamental rights, it is also part of the basic structure of the Constitution. There has to be balance between non-enforceable DPSPs and enforceable fundamental rights. If you tilt this balance in favor of all DPSPs, you are doing something which is against the basic structure of the Constitution. So with this constitutional amendment, what Parliament you are doing? You are giving superiority to all DPSPs over three fundamental rights. We will not accept this because this violates the balance, the delicate balance between DPSPs and fundamental rights. And this balance is also part of the basic structure of the Constitution, which means this amendment was declared unconstitutional. Which means the position now remains what it was before this amendment. And what was it before this amendment? That two DPSPs, 39B and 39C, they have superiority over three fundamental rights, 14, 19, and 31. Then something else happened. In 1978, 44th Constitutional Amendment Act was passed. Article 19(1)(f) and Article 31, they were repealed. And instead, Article 300 capital A was added, which talks about right to property as a constitutional right. And I told you in fundamental rights why right to property was deleted as a fundamental right. We will discuss such a provision in DPSPs. In 1978, when the government, because at that time it was the Janata Party which was in power, because in 1977 elections, Srimati Indira Gandhi's Congress was defeated, although her party did very well in the southern India. But in the northern India, her party was wiped out. She bagged only 2 seats in North India. And Janata Party came to power. Shri Morarji Desai became the Prime Minister. And when the minister introduced a bill to delete Article 19(1)(f), to delete Article 31, what was the reason given? What was the rationale given? The reason given was there is some sanctity which is attached to fundamental rights. Why do we call fundamental rights as fundamental? Because they are fundamental for the growth and development of an individual. Without these fundamental rights, it is not possible for an individual to explore his true potential. But specific to right to property, it has been amended multiple times. It was amended in 1951, then again in 55, then again in 60s, then again in 70s. So when you amend a fundamental right repeatedly, you also reduce its sanctity. That is why instead of making or retaining it as a fundamental right, we will make it other constitutional right under Article 300 capital A. So the reason given for the repeal of right to property as a fundamental right was that there is some sanctity, some uniqueness which is attached to fundamental right. They should not be subjected to repeated amendments. If they are subjected to repeated amendments, they lose their sanctity. And for that, we are converting right to property from a fundamental right to other constitutional right. But listen to me carefully. 31A continues. 31B continues. 31C continues. It is only 31 which has been repealed. That 31 which spoke of that if the state wants to compulsorily acquire a property, state has to provide compensation. And this compensation has to be fair. It is this Article 31 which has been repealed. But Article 31 capital A, which says when the state wants to acquire land, estate, take over the management of the factory, this acquisition shall not be deemed violation of Article 14, 1931. This 31A continues. Ninth schedule continues. This 31C, which gives superiority to 2 DPSPs over 3 fundamental rights, even this 31 capital C continues. So the relationship today is that there are 2 directive principles which are superior to 3 fundamental rights, 14, 19, 31. Although 31 has been deleted, so you can say 14 and 19. So 19 has also been deleted. No, not the full 19. 19.1a, freedom of speech and expression, continues. 19.1b, right to form associations, unions, and corporate, right to assemble peacefully without arms, right to form unions, associations, and cooperative societies, right to move freely throughout the territory of India, right to reside and settle anywhere within the territory of India, right to take up any trade, occupation, profession that exists, that continue. All these other natural rights under Article 19 continue. It is only 19.1f which has been repealed. So there are 2 DPSPs, 39B and 39C, which have superiority over 3 fundamental rights. Any questions? Let me know. Any questions as of now? And then Constitution was amended. That doesn't mean to amend the Constitution, you have to impose emergency. Or that doesn't mean that whenever emergency is there, you have to amend the Constitution. No. It's for 2 independent events. But when we say directive principles of state policy, they are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement them because these are fundamental for the governance of the country. One by one, most of these DPSPs have been implemented. If I can give you the list, for example, DPSP under Article 40 talks about organization and setting up of village panchayats. Panchayati Raj institutions have been set up. And we will discuss in local government article or 73rd amendment to the Constitution. Right to work, to education, and to public assistance in certain cases. Right to work in certain cases. If you are in rural India, you belong to below poverty line family, you have the right to work. 100 days of employment is your right. What is that right? MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. Right to education. In fact, this right to education, which was meant to be a DPSP, was converted into a fundamental right in 2001, 86th Constitutional Amendment Act. So even this DPSP we have implemented. Provision for just and human conditions of work and for maternity relief. Just and human conditions of work. We have Factories Act, which lays down the minimum and the maximum number of hours that you can be required to work in factory. If you are working in a corporate sector or in government sector or anywhere in organized sector, not in unorganized sector, in organized sector, the employer has to provide you insurance. If you're working overtime, the employer has to provide you incentive. If you are a woman and you're expecting a child, then 26 weeks of paid maternity leave for 2 children is your right under the Maternity Benefit Act. That means right provision for just and humane conditions of work. If you're working in, let's say, construction industry, you have to provide protective gear to your workers, a helmet, good protection. In case of some mishap, unfortunately, you'll have to provide insurance, some compensation. All these things which are mentioned in the Factories Act, their principal objective is to provide just humane conditions of work. And maternity relief, 26 weeks of paid maternity leave for women up to 2 children. That means even Article 42 we have implemented. Article 47, which talks about duty of the state to raise the level of nutrition and the standard of living and to improve public health. Are we not providing midday meals in the schools? Are we not providing Ayushman Bharat as a scheme, as insurance in medical sector? Are we not providing nutritious food in the form of Food Security Act? 2013, where rice at 1 rupee per kg, wheat at 2 rupees per kg, pulses at 3 rupees per kg. These food items are given at subsidized rates to 67% of our population to raise their level of nutrition. Even Article 47 we have implemented. Article 46, state shall take steps for the welfare of SCs and STs, those who belong to socially and educationally backward class of citizens. And I don't have to explain what are the benefits, what are the steps that the state has taken for the welfare of SCs and STs. That means even Article 46 we have implemented. Article 49, which talks about protection of monuments and places and objects of national importance. Look at the institutions of national heritage. Look at the ancient monuments that we have. All these are protected. Archaeological Survey of India, there are so many institutions which are responsible for protecting, conserving these monuments, which means even this Article 49 we have implemented. Article 50, which talks about separation of judiciary from the executive. Have we implemented this? Yes. In 1973, when Criminal Procedure Code was implemented, the judicial powers of the magistrate were snatched and these powers were given to the district judge. That means district judge will have judicial powers, executive magistrate will have executive powers. What we have implemented, Article 50, which is a directive principle, which talks about separation of judiciary from the executive. And Article 51, promotion of international peace and security. We tell Putin, war is not the solution. On Ukraine, you have to dial down because we want to promote international peace and security. That should be the directive to the state. And we have never waged a war against any country. We have never initiated a war against any country because the guiding philosophy, what are the principles that the state has to keep in mind? That you have to promote international peace and security. Long story short, all DPSPs have been implemented. Despite the fact that Constitution said these DPSPs are not enforceable in a court of law, the state has implemented almost all DPSPs. except the Uniform Civil Code. And what is a Uniform Civil Code? Let's discuss. We have civil laws, we have criminal laws. And I've told you previously what's the difference between a civil wrong and a criminal wrong, a civil case and a criminal case. Civil case between two individuals, criminal case where one of the party is the state. Criminal laws are common for all no discrimination on the grounds of religion. Criminal laws are common for all without any discrimination on the grounds of religion, which means whether a Hindu or a Muslim commits rape, both will be booked under section 376 of Indian Penal Code. If a Sikh or a Parsi commits murder, both would be booked under section 302 of Indian Penal Code. If a Buddhist or a Jain do some unnatural activity, which is against the order of nature, both will be booked under section 377. So criminal laws are common for all without any discrimination on the grounds of religion. Clear? Even civil laws are common. Civil laws are common. For example, contract. I have signed a contract with you. If I violate this contract, under the Contracts Act, some action can be taken. I have to provide you compensation. I have to provide you money. And there is no discrimination on the grounds of religion. That if a Hindu violates a contract, there is a different compensation that you will have to provide. If a Muslim violates a contract, there is a different compensation that you will have to provide. But within civil laws, there are some laws which are called personal laws. And which are these personal laws? Related to marriage, related to divorce, related to inheritance, related to adoption. It is with respect to these personal laws that different religions are governed differently based on that particular religion's philosophy. Criminal laws are common for all, no discrimination on the grounds of religion. Civil laws are common for all, no grounds of discrimination on the grounds of religion. But within civil laws, there are laws which are called as personal laws. This is where there is a difference. There is discrimination. Or should we say, every religion is governed by their own set of laws when it comes to marriage, divorce, inheritance, adoption. Why? Because this is our colonial legacy. Why colonial legacy? Because in 1857, when the revolt of 1857 broke out, when a massive revolt broke out in the northern and central part of India, which nearly swept away the British rule, then the British realized that one thing that we should not do, we should not interfere with the religion of these Indians. Because these guys, my God, they're so touchy about their religion. So we snatched their economy. We destroyed their livelihood. They did not even raise their voice. But the moment we interfered with their religion, look at the revolt. Although the immediate trigger was that greased cartridge, which you had to cut. And when you chew it, the cartridge, the top of it was made up of, the allegation was cow meat and pig fat, which is, cow meat is not acceptable to Hindus, pig meat is not acceptable to the Muslims. So ultimately affecting the religious sensibilities of Indians. And this was the immediate trigger, and look at the revolt. And previously, there were some steps taken by the British to somehow make laws, personal laws, slightly better. Slightly better in the sense, sati was considered to be part of the Hindu tradition. Whether rightly or wrongly, whether justified or unjustified, let's not get into that. But sati was abolished. Lord William Bentinck, with tremendous support by Raja Ram Mohan Roy. British interfering with the religious practices. Sati was abolished. Widows were not allowed to remarry, particularly the widows which belonged to the Brahmin community. 1856 Widow Remarriage Act was passed. Ishwar Chandra Vidyasagar played a pivotal role, and even now, even the Brahmin widows were allowed to remarry. So some steps, incremental steps were taken. Sir Syed Ahmad Khan would ask the British that please ensure that Parda is abolished. We don't need Parda system. So some steps were taken by the British to somehow make Indians liberal. Some of the regressive practices associated with religions, they were sought to be diluted or deleted by the British. But the moment 1857 broke out, then the policy of the British was non-interference in the religious matters. Even if these practices are horrible, do it, but support us. We will not interfere with your religious practices, but you support us. And that is how Muslims in their personal laws were governed by their own law. Sharia, for example. So let's say, for example, for Muslims, a husband can marry at the same time 4 wives. That's part of their personal laws. That's allowed. Only husband can grant a divorce to his wife. Wife cannot grant divorce to husband. Who will get the property? What is the percentage of property that a girl would get? What is the percentage of property that a man would get? What is the percentage of the property that the wife of this deceased would get? All that is part of Sharia. All that will continue for all the Muslims. Muslims cannot adopt a child. Even if you adopt a child, he or she won't be called your legal heir according to the Sharia laws. Similarly, Christians, they will be governed by their own laws. Till death do us part. We will not divorce each other. That will continue. Hindus will be governed by their own laws. Whether we will give inheritance to women or not, that we will decide. Our religious scriptures will decide. British will not decide. That means all the religious communities, they were governed by their own laws, by the laws of their own religion. When it comes to these personal laws, for criminal laws, there was no basis on the grounds of discrimination on the grounds of religion. For example, even if there is a religion which talks about that if there is a thief, you have to cut the limb of that thief, or there is a religion which says if there is a thief, you have to forgive him. We can't incorporate these religious sensibilities in our criminal laws or in our civil laws. But when it comes to the personal laws, specifically to marriage, divorce, inheritance, and adoption, every religion will be governed by their own religious identities, by their own religious principles. Constitution said under Article 44, the state shall endeavor or strive to enact a uniform civil code, UCC. And what is UCC basically? If criminal laws can be common without any discrimination on the grounds of religion, if civil laws can be common without any ground for discrimination on the grounds of religion, personal laws should also be common. So that marriage laws, divorce laws, inheritance laws, adoption laws, these should be common for all religious communities. Different religions should not be governed differently. That is what uniform civil code exactly means. But this was part of the directive principles of state policy. Constitution said DPSPs are not enforceable in a court of law. Nevertheless, they shall be fundamental for the governance of the country. But when these are not enforceable in a court of law, that means it is the discretion of the state when it wants to implement this. But even till 2023, it has not been implemented. And it's not that Supreme Court or our judiciary is blind to it. They don't recognize it. They don't value it. For example, Shah Bano. She was in her 60s or 70s. She was married. Her husband, who was an advocate in Madhya Pradesh High Court, fell in love with a young lady and decided to marry her. And he decided to divorce Shah Bano. So Shah Bano was given divorce. If a Hindu woman is granted divorce by her husband, this Hindu woman is provided maintenance for her entire life. That means the husband, who is now the ex-husband, has to provide money to this wife, his ex-wife, so that she can live her life. That is what we call maintenance for her entire life. Why? Because when India got independence, Dr. Ambedkar and Pandit Nehru, they decided to come together and reform Hindu laws or Hindu personal laws. I'm mentioning reform in quotes because it was reform for them, but maybe for others it was interference. So what you call reform may be interference to others. What I call interference may be reform to someone else. So if the idea is to have a uniform civil code, that means one common code which will be applicable to everybody, why not first initiate the reform of the Hindu laws itself, according to Dr. Ambedkar and Pandit Nehru? Why not allow intercaste marriages? Because intercaste marriages were not allowed. Why not give women her due share in inheritance? Why not give women the right to grant divorce as well? So Pandit Nehru, Dr. Ambedkar, they felt that since country was partitioned on the grounds of religion, we have to assure minorities as well that you will be safe in this India. But what we can do, these personal laws have to be common for everybody. First, we will initiate the reform of the Hindu laws. That is how 3 Hindu code bills were passed. Related to marriage, the Hindu laws were codified and reformed so that there is equality in terms of marriage. Related to divorce, related to succession, that means who gets to inherit the property, what should be the percentage of that property, should women be given property rights or not. All these things were mentioned in the 3 Hindu code bills, and these 3 Hindu code bills were passed. Dr. Ambedkar was still not happy with these Hindu code bills because he thought that Pandit Nehru has now succumbed to the pressures of the far right, has succumbed to the pressures of the orthodox Hindus. He is trying to please them by watering down these laws. Dr. Ambedkar was not happy. Dr. Ambedkar basically then resigned as the Law Minister of India. And then at a ceremony a historic ceremony which is celebrated today, he renounced Hinduism and adopted and embraced Buddhism, along with lakhs of his followers. But be that as it may, the first step was taken so that if we are talking about uniform civil code, listen to me carefully. If we are talking about uniform civil code where one code related to marriage, divorce, inheritance, adoption should be common for all religions, first let's have some commonality within Hinduism. Because for Brahmins there are different rules, for Dalits there are different rules, for women there are different rules, for men there are different rules. Can't we have some sort of common structure, common code for all Hindus? And if we will reform the majority religion, personal laws related to the majority religion, then one by one we will take up the personal laws of the minorities. Then they can't complain as well. Why? Because we will tell them, if we can do this with Hindus, why can't we do with Muslims, Christians, Parsis, and others? That was the intention, that was the logic. But Shabano, when she was divorced by her husband, according to the Islamic law, according to the Sharia, because in personal laws you are governed by your own religion. According to Sharia, this husband, who is not the ex, has to provide maintenance to his wife only for 3 months. Not for the entire life. Shabano approached Madhya Pradesh High Court. My lord, why there are discrimination? I said, why? My Hindu sister, when she gets divorced, maintenance is provided to her for her entire life by the husband. And look at me, I'm old. I can't earn livelihood. My husband says, since we are governed by the Shariat laws, by the Islamic laws, I will provide you maintenance only for 3 months. Why this discrimination on the grounds of religion? Madhya Pradesh High Court said, you are right. Shabano's husband provide her maintenance for her entire life. I said, why? But she is no longer my wife. Don't argue. If you want, go to the court. Go to the Supreme Court. Shabano's husband approached the Supreme Court. Supreme Court said the same thing. Give her maintenance for her entire life, not just for 3 months. And Supreme Court said something spectacular, said something prescient. Supreme Court said, we regret that even after so many decades of independence, we have yet to enact a uniform civil code. If there was a uniform civil code, such a problem would not have existed in the first place. Shabano case would not have arisen in the first place. This was 1985. And in 1985, there was one good-looking, smart individual as the Prime Minister, Rajiv Gandhi. So-called leaders of the Muslim community, the clerics, the mullahs, they approached Rajiv Gandhi and basically threatened him. We will not give you votes. Then you can't remain the Prime Minister. Do what you want to do. I said, but what do you want? We don't want any interference in our personal laws. Supreme Court has said provide maintenance for the entire life. Why? This goes against the Islamic principles. Islam is in danger. I said, what do you want me to do? You have the majority. You have more than 400 MPs in Lok Sabha. Pass a law, nullify this judgment. Okay, don't worry, we'll do that. And the parliament enacted a law known as Muslim Women Protection of Rights on Divorce Act. According to this law, maintenance would be provided only for 3 months. But maintenance amount was enhanced. Rajiv Gandhi said, don't worry. What has the Supreme Court said? Supreme Court said, provide maintenance for entire life, not just for 3 months. And what do you want? We want to provide maintenance only for 3 months. That's it. Otherwise, no vote. When no vote, no PM. Nothing. Go back to Italy. Whatever it is. This is just humor. I'm not privy to such conversation. This is just to make you understand. And ultimately, this law was passed. When this law was passed, it said that although the maintenance amount that this husband has to pay to his ex-wife will be increased, but this maintenance will be provided only for 3 months, not for the entire life. And then there was allegation against Rajiv Gandhi that you are pandering to the Muslim interests. Hindus would be left out. You have to do something for them as well. And when Ram Mandir is being constructed right now at Ayodhya, which would be open next year, if you read the statements of Dr. Subramaniam Swamy, he says that if there is a person who is responsible for the construction of the Ram temple, it is Rajiv Gandhi. In fact, Subramaniam Swamy and Rajiv Gandhi, they were close to each other. Once Subramaniam Swamy and Sonia Gandhi were also close to each other. But now, he just wants them to be in jail, including their son. But be that as it may, what Rajiv Gandhi did, when there was a dispute on this Ram Jannabhoomi, where Babri Masjid stood, and the allegation was that this Babri Masjid was constructed on the ruins of the Ram temple. Ram temple was destroyed. That's how Babri Masjid was constructed. And this was a problem. There was a dispute on this between Hindus and Muslims, even during the British period, even during the colonial period. But as soon as India got independence, idols of Lord Ram appeared under the central dome of Babri Masjid. The central dome of Babri Masjid, under that the idols appeared. And when idols appeared, the Hindus thought that, look, Lord Ram has himself come inside Babri Masjid and claiming his place of birth. And others said, how can idols appear on their own? Somebody would have sneaked in the idols and placed the idols under the central dome. But the government immediately sealed the mosque, immediately sealed the entire area and said no further prayers can happen. But even then, just next to the Babri Masjid, there used to be a place known as Ram Chabutra. And that Ram Chabutra used to be worshipped by the people, by the Hindus. Not closer there, but from outside. There were some disturbances during this period as well, but the gates of this Lord Ram temple, or this makeshift Ram temple or the Ram Chabutra, it was closed. Rajiv Gandhi said, on one hand, we are passing this law which will please the Muslim community. On the other hand, the Faizabad court decided to open these locks of Ram Chabutra and allowing Hindus to worship. And the central government did not object to this, did not do anything to prevent the situation from happening. So it was argued that it was Rajiv Gandhi who was responsible for opening the doors of the Ram temple, which ultimately paved the way for the destruction of the Babri Masjid and ultimately the Ram Jannabhoomi movement, which has now culminated into the construction of a mega Ram temple at Ayodhya. But unfortunately, or fortunately, he could not reap the benefits of both these things, and ultimately he was voted out of power in 1989. But be that as it may, this is what happened in 1986. Even this was challenged in the court. Daniel Latifi, who was the lawyer of Shah Banu, he filed a case against this law, saying, my lord, how can the law passed by the parliament nullify the judgment of the court? You said provide maintenance for their entire life, and the parliament is saying maintenance only for 3 months. How is that possible? The Supreme Court asked the government, how is this possible? Supreme Court said, we have to respect the personal laws of a community as well. My lordship, you wanted maintenance to be provided for the entire life, right? Yes. We will calculate that amount. We will calculate this maintenance amount, and we will provide the same amount which would last for the entire life of that woman, but we will provide only in 3 months, so that we balance your lordship's judgment as well, the Islamic laws as well. Your lordship's judgment, you basically want that this woman should not suffer for the lack of funds, for the lack of money. That means money should be given to her which will last her entire life. We will give that money. The husband will give that money as maintenance, which would last for her entire life, but only for 3 months, not after that. Because after that, she's not his wife. The court said, okay, this law is constitutional, but ensure that maintenance amount is enhanced so that this enhanced maintenance amount lasts for the entire life. But even then, there is no such thing as uniform civil code. And then there are people who say, yes, uniform civil code should be implemented. And there are also people who say, no, it should not be implemented. Let's look at both the arguments. Uniform civil code should be implemented because it is a DPSP, and implementation of the DPSP is fundamental for the governance of the country. DPSP should be implemented, or this uniform civil code should be implemented in the name of secularism. So when we say implement DPSP, we keep in mind the preamble's objective of a secular state. In secular state, there should be no discrimination on the grounds of religion. When there is no discrimination on the grounds of religion, that means the state has to treat everybody equally. By having personal laws related to your own community, which is different from others, you're violating secularism. So for the sake of secularism, implement uniform civil code. Not just that, for gender justice. There was intervention of the court, and that is how Hindu woman, Hindu daughter was given inheritance rights. Otherwise, she was not given inheritance rights. Muslim women today, even today, cannot divorce her husband, even if the husband is abusive. So the laws related to personal laws, they are tilted in favor of men. Same goes with the plight of the Parsi woman. If she marries a non-Parsi, she cannot enter the fire temple. She cannot perform the religious rituals. She cannot inherit the property. But if the laws related to marriage, divorce, inheritance, adoption are common for all religious communities, this law would ensure that there is no discrimination on the ground of gender. So for the sake of gender justice, for the sake of secularism, for the sake of constitution, because DPSPs are fundamental for the governance of the country, implement uniform civil code. And when uniform civil code would be implemented, there will be no claims of minority appeasement, which has polarized the society. BJP says development of all, appeasement to none. They claim that Congress is appeasing the minorities. Congress claims that BJP is assaulting the minorities, denigrating them to lesser citizens, second-class citizens. And principal reason given by both the parties is uniform civil code. BJP says we want to implement uniform civil code, but Congress has not done that since the independence because they were in power for most number of years. If uniform civil code is implemented, then the narrative in the nation would be that there is no minority appeasement. And ultimately, what would happen? This polarization, which has been created in the society in the name of religion, where the lack of uniform civil code has played a very important role. This polarization would take a backseat, and hopefully, we will have a stable polity, stable society. For all these reasons, uniform civil code should be implemented. But there are others who talk about something else. They say it should not be implemented. Why? Number one, the reason that they give is that Constitution talks about uniform civil code and not a common civil code. What is the difference between the two? They say when Constitution talks about uniform civil code, Constitution could also have mentioned common civil code. But Constitution deliberately spoke of uniform civil code and not common civil code. That means there is a difference between the term uniform and common. What's the difference? If it was a common civil code, that means there will be a common law for all religious communities. Just like we have a common criminal procedure code, a common civil law. If it was a common personal law as well, that means this law would be applicable to all the religious communities. But Constitution does not talk about a common civil code. Constitution talks about a uniform civil code. And what is the difference between common and uniform? One law for Hindus, one law for Muslims, one law for Christians, one law for Parsis, one law, different laws. But this law, which is for Hindus, should be uniformly applicable to all sections and classes of Hindus. No discrimination on the ground of caste, no discrimination on the ground of sex. There should be one law for Muslims, different law for Muslims, but uniformly applicable to all the classes and castes of Muslims. That is what some constitutional experts say. They say Constitution under Article 44 does not talk about a common civil code. It talks about a uniform civil code. That means a law for Hindus, different law for Muslims, different law for Christians. But this law should be uniformly applicable to all classes and sections of Hindus or Muslims or Christians or Parsis. Argument number one. Argument number two. They say, look at the wording of Article 44 as well. Other articles, other DPSPs, they say the state shall provide for what? Equal pay for equal work. The state shall ensure that the standard of living of society increases. The state shall provide for separation of executive from judiciary. The state shall ensure international peace, security. The state shall do this, the state shall do that. But Article 44 does not talk about the state shall ensure uniform civil code or the state shall enact a uniform civil code. It says the state shall strive. Look at the beauty of these words. The state shall strive, shall take a lot of steps, ensure that through consensus we implement a uniform civil code. That means by incorporating this term strive, it says that there has to be negotiation. There has to be negotiation with all the religious communities. And that is how through consensus we can provide for a uniform civil code. It cannot be done unilaterally. There are others who say you can't implement a uniform civil code because there would be challenges. What are the challenges? Challenge number one, let's assume there is a law which is common for all. Let's assume for a while that there is a law related to marriage, divorce, inheritance, adoption, which is common for all. But this law will be based on Hindu law or Christian law or Parsi law or Islamic law. What would this law be based on? What would be the central features of this law? That is by somebody like J. Sai Deepak, a constitutional expert. Has written a couple of books as well. Is a lawyer as well. He says, I am more skeptical about uniform civil code because I know when uniform civil code would be implemented, it basically would be against Hindu interests. Because when there will be a common law, I will see that this common law will be against the Hindu principles, Hindu philosophy. So right now, at least we are following our own laws based on our particular religion. Now tomorrow there will be a secular law which will not take into mind the Hindu interest, Hindu ideology, Hindu philosophy. So he says, first I have to look at the draft. What is this uniform civil code that the government is talking about? Then we will see whether to support this or oppose this. But our history says that whenever the government interferes with the Hindu laws, it always is against the Hindu interests. According to, not me, J. Sai Deepak. But there is another challenge. The challenge is Article 44 is what? DPSP. Article 25 is what? Fundamental right. There are only two DPSPs which have superiority over three fundamental rights, 39B and 39C, over Article 14, 1931. But Article 44 does not have primacy over any fundamental right. So if Uniform Civil Code is implemented, and let's say this Uniform Civil Code bans polygamy, saying you can't have more than one wife or you can't have more than one husband. But under Article 25, you have the fundamental right to practice your religion. If your religion allows you to marry more than once at the same time, and this right to practice that religion is your fundamental right, what if DPSP tries to snatch it? What will prevail? Fundamental right or DPSP? Fundamental right. So if your religion allows you to marry, and right to religion is your fundamental right to practice religion is your fundamental right, how can the state snatch it from you? Because to implement DPSPs, implement this, but don't violate fundamental rights, according to Supreme Court. Forget about this. Let's look at Article 29. Every section of citizens who have a distinct language, script, or culture of their own, and they want to preserve that culture, they have the fundamental right to preserve that culture. So we gave some instances, marriage by capture. This marriage by capture either is to be made applicable to everybody or nobody. So if you make marriage by capture available to everybody, then we don't need Uniform Civil Code because that is rape in rest of the country. But for some tribal cultures, it is part of their culture, should be recognized. But if Uniform Civil Code is implemented, that means common laws for marriage for everybody. That means marriage by capture, marriage by intrusion. A girl marrying the grandfather would be incest. A man marrying the mother-in-law would not be acceptable. All these practices would disappear because Uniform Civil Code is now implemented. But Article 29 is a fundamental right. And can a law to give effect to DPSP violate fundamental right? No. These are the challenges. And that is why even the Law Commission of India has said the time is not ripe for Uniform Civil Code. There can be debate, but Uniform Civil Code is not required right now because time is not yet ripe. The question Uni is asking, then why triple talaq is removed? You may be surprised. Triple talaq was not declared unconstitutional by the judiciary. Judiciary did not say instant triple talaq is violation of fundamental rights and therefore is unconstitutional. Then what happened? There were 5 judges who had to decide on triple talaq, right? If 3 judges would say that triple talaq is unconstitutional, triple talaq would go as unconstitutional. 2 judges said, we can't interfere. Same as what Supreme Court said yesterday vis-a-vis right to marriage in the LGBTQ community. They placed the ball in the court of the parliament, saying, let parliament take a call, we will not interfere. Justice Nazir, Justice Kehar. 2 other judges, they said instant triple talaq is unconstitutional because it violates fundamental rights. So 2 judges are saying we will not interfere. 2 other judges are saying it is unconstitutional. Now the ball is in this court of a judge, Justice Kurian Joseph. He did not even look at this question from the prism of constitutionality or unconstitutionality. He looked at this question from the prism of religion. And he said instant triple talaq is against Islam. Because Justice Kurian Joseph said in Islam, the divorce has some methodology to follow. Whenever you divorce somebody, 2 steps are important. One is arbitration. The other is reconciliation. Reconciliation in the sense, if the husband says talaq to his wife, but then the husband regrets and says, I'm sorry, I love you. I should not have done this. I was under the influence of liquor. I was under the influence of drugs. I was under the influence of psychotropic substances. I'm sorry, let's patch up. So there has to be scope of reconciliation. Or there has to be arbitration. Elders will come, family members will come, village Panchayati Raj members will come and try to convince this couple to stay together. Because after all, marriage is an important institution. Divorce should be the last resort. So there has to be a scope for reconciliation and arbitration. Once both these objectives fail, then the divorce has to be granted. That is why Kurian Joseph said, look at the other forms of talaq in Islam. You say talaq and wait for 30 days. Why 30 days? Because in this 30-day period, there has to be arbitration and reconciliation. Then wait for another 30 days. Total, you have to wait for 90 days. So that in this 90-day period, there is some sort of reconciliation, there is some sort of arbitration. If everything fails, then divorce is granted. But when you say instant triple talaq, when you give talaq, talaq, talaq 3 times in a single utterance, and the divorce is granted, which means you don't have to wait for 90 days, which means there is no scope of arbitration, there is no scope of reconciliation, which means this form of divorce, this form of talaq is un-Islamic. That is why we say instant triple talaq was not declared unconstitutional, it was only set aside. It will not continue. On what grounds? 2 judges said unconstitutional. 3 other judges said no, on different ground, on Islamic grounds. That is why there is this difference. So these 26 weeks of paid leave can be applicable to private companies? Yes. So triple talaq is still followed? It's not followed because for that we have a law known as Muslim Women Protection of Rights on Marriage Act, under which if a husband is saying talaq, talaq, talaq 3 times, it's a crime. The husband would be arrested and sentenced to jail for up to 3 years. And what will happen to the marriage? Marriage continues. Marriage would not be dissolved. Okay, so the challenges are uniform civil code cannot be implemented. Why? Because constitution only talks about a uniform and not a common civil code. Constitution only talks about the state shall strive. It does not talk about the state shall enact. There are challenges. If uniform civil code is implemented, what about Article 25? What about Article 29? And at the same time, the Law Commission also has said that the time is not ripe right now for a uniform civil code. There can be debate, there can be discussion, but maybe not implementation. Let's wait and watch what will happen, because the committee has been set up by the government to look into uniform civil code. Whether it will be implemented or not, we'll have to see. If it is implemented, we'll have to see how it is. What are the provisions of uniform civil code? But what is the alternative? If not a uniform civil code, what is the alternative? And the alternative is Goa. If there is one state in India where we have a uniform civil code, that state is Goa. What is the Goa model of uniform civil code? Let's discuss. Is this a good model? Let's discuss. If it is not a good model, then what is the other alternative? The Special Marriage Act of 1954. Is that good, bad, or ugly? And what did the Supreme Court say yesterday on legalizing marriage for the same sex couples? All this we will discuss after the break. Remaining features. Where we have a uniform civil code, and that is Goa. When it comes to matters related to marriage, divorce, inheritance, or adoption, there is no discrimination on the grounds of religion. That means same laws related to marriage, divorce, inheritance, and adoption are applicable to all the religious communities who are there in Goa. Why Goa? Because you would know Goa was under the Portuguese. And when Goa was to be made part of India, there was a condition that all these Portuguese laws should continue in Goa even after Goa becomes part of India. And one such Portuguese law was laws related to the personal laws. That is how former Chief Justice, Justice Sharad Arvind Bobde, S.A. Bobde, he said that if in Goa we can have a uniform civil code, and it is continuing right since the time Goa became part of India, why can't we have a similar provision, similar set of conditions in the rest of the country? That's how we can implement a uniform civil code. But yes, in Goa there is a uniform civil code. But as you dig deeper, you see some problems in Goan model as well. It can also mean uniformity in discrimination. If there is a uniform civil code, but the code itself is discriminatory, that means this discrimination will be uniformly applicable across the religions. And what is that discrimination? Let's look at these conditions one by one. Procedures for registration of marriage are different for Catholics as compared to the procedures applicable to non-Catholics. What are the procedures? Basically, two signatures are required. There is a boy and a girl, man and a woman who want to get married. The procedure is that you have to give two signatures. One at the time of intent, second when you actually solemnize this marriage, when you actually do this marriage. This intention, that means when you want to get married, you will have to give your intention that yes, I am in my sound mind and body, I want to get married, so my intention is to get married. This signature is taken by both the parties, and ultimately, first signature requirement is done. And the second signature is done when actually the marriage is registered, when actually the marriage is solemnized. But this second signature is not required for Catholics. If this marriage takes place at the church, so if the marriage takes place at church, we consider that at this church, second signature is taken. That means there is no requirement of a second signature, but the second signature is required for every other religious community. That means special procedure for Catholics, special provision for all other religions. That means for all other religions, discrimination is uniform. That is discrimination number one. Number two, this marriage which is solemnized at the church, it has an option of being annulled in the church for specific reason, such as non-consummation of marriage. Let's say, for example, here is a Catholic and here is a non-Catholic. And now the marriage has taken place. Now, once marriage has taken place, that means it can also be annulled as if marriage never took place. Or it can be, there can be a procedure for divorce. That means marriage took place and now they've decided to separate from each other. That's divorce. That's the difference between annulment and divorce. Annulment is as if marriage never happened. Divorce is marriage happened and now it is to be set aside. For Catholics as well as non-Catholics, the grounds of divorce are same, common. Divorce can be through mutual consent. Both husband and wife, they now decide that we are not good together. We have irretrievable differences which we cannot sort out, and let's part ways. Through mutual consent for everybody, divorce is allowed. Men can also give divorce, women can also give divorce. That is common for everybody. If there is cruelty in marriage, there can be divorce. If one of the partner is an impotent, there can be divorce. So grounds for divorce are common for all, except for Catholics. If the marriage is solemnized in the church, one additional ground for annulment is prescribed if the marriage is not consumed. What is this non-consummation of marriage? If boy and a girl, husband and wife, they got married but they did not have sex, they did not indulge in sexual intercourse, which means the marriage was not consumed. This non-consummation of marriage is a ground for divorce, but only for those marriages which are solemnized at the church. And who will solemnize marriage at the church? The Catholics. For all others, this is not a ground for the annulment of marriage. That means for all others, there is discrimination, but uniform discrimination for everybody. Not just this. There is something unique to Govan model, which is the regime of communion of assets. What does that mean? Here is boy, and there is a girl. Girl can inherit property, can also purchase property. She may have inherited some property from her parents. She may, because of her own income, have purchased this property. Same goes with boy as well. The boy would or may have inherited the property, may purchase from his income property as well. And let's say these are the 4 properties of boy. These are the 5 properties of the girl. At the time of marriage, if they want, if both husband and the wife, they want that all these 8 properties we should hold together, control together, we should be the joint owners of all the properties, that will continue. And this is common for everybody, common for all the religions. That means if husband and the wife, they have some property, they want that this property after their marriage should be jointly controlled by them. That is also a provision. But if they want that, no, my 5 property I will keep separately, your 4 property you keep separately, that is also something that can happen. But even if it's a regime of communion of assets, which means common control over the assets, but the manager is husband, that means even if this property is jointly controlled by them, or after their marriage, whatever they have earned, whatever property they have bought, all those will have to be clubbed together. Before marriage, they have an option whether to club together or not. After the marriage, whatever property you have acquired will be clubbed together. That means you will be the joint owners of this property. But even then, who is the manager of this property? It is the husband. And there have been instances in Goa where the husband has given out this property for rent. And whatever rent he gets, he does not share it with his wife. He keeps it with himself. Why? Because he is the manager of this property. That means gender bias, not just bias on the grounds of religion, where for Catholics and non Catholics there are different procedures, there are different rules for the annulment of marriage. But even on the ground of gender, there is discrimination. That means uniform discrimination. It's not that Hindu women would have some more rights as against to Muslim women. No, all the women would be at a disadvantage belonging to all the religious communities because the manager of this property is always a husband. Not just this. If Goa has a uniform civil code, if Goa is the only state where we have a uniform civil code, can this Goa model be applied in the rest of the country? Some say yes, some say no. Yes, why? Because the laws related to marriage, divorce, inheritance, adoption are common. So if something uniform can happen in Goa, why can't it happen in the rest of the country? But as you dig deeper, you see that there is still discrimination on the grounds of gender. There is still discrimination on the grounds of religion. If you're Catholic, different procedure, non Catholic, different procedure. Then what is the only alternative? The only alternative is a special marriage act. And what is the special marriage act? Which was passed in the year 1954. I told you during the colonial period, British initially tried to reform the personal laws of different communities in India. But then they realized that Indians are so touchy about their religion that we will not touch it. So after the revolt of 1857, if an inter-religious marriage was to be solemnized, if a Hindu and a Muslim would want to get married, will this marriage take place under the Hindu practices or under the Islamic practices? British said we should not encourage this. Because Hindus will say you want to convert Hindus to Islam. Muslims will say you want to convert Muslims into Hinduism or you want to convert them into Christianity. We cannot afford this. We want to stay away from this. So if boy and a girl, you are deeply in love with each other, but you belong to two different religions, what you have to do? You have to renounce your religion. In order to get married. During the colonial period. That means during the colonial period, during the British period, if a boy and a girl belonging to two different religions, they wanted to get married, the only option available to them was they have to give up their religion. Give up their religion and then you can get married. Because we should not be seen as encouraging these inter-religious marriages. Because religion is a touchy issue with Indians and we don't want our rule to be jeopardized. Then Parliament in 1954 felt that there is a need. What if Hindu and a Muslim, they want to get married? Will they get married under the Hindu laws or under the Sharia laws? What if woman does not want to convert? What if husband does not want to convert to another religion? They want to maintain their individual religious identity, yet be bound in this relationship called marriage. There should be a law which should encourage inter-religious marriages or inter-caste marriages, and such a law is Special Marriage Act. The Special Marriage Act was meant to facilitate interreligious marriages, but it actually creates huge hurdles. Suhasini Haider, she is a journalist, works with The Hindu. Previously, she was with CNN IBN. She's also the daughter of Dr. Subramaniam Swamy, married to a Muslim. She writes that today it is convenient, it is easy to get married by converting to another religion rather than getting married under the Special Marriage Act, because Special Marriage Act creates a lot of unnecessary problems and hurdles. A law which was meant to facilitate interreligious marriages is now creating hurdles. Why hurdles? Let's look at the provisions. Legally, India has a clear route to interreligious marriage, the Special Marriage Act of 1954, under which a couple, no matter what their caste or religion is, they can marry without any need for conversion. But when we look at the provisions, there is something known as notice period. Muslim and a Muslim, they want to get married. They can marry today, in 1 second, in 1 minute. But Muslim and a Hindu, if they want to get married, they have to first give a notice period. What is the notice period? Notice period like when you resign from your company. Okay, you want to resign but serve the notice period. What is this notice period? You have to go to the marriage officer and you have to tell him or her your intention of getting married. But then, if you approach today, your marriage can take place only after 30 days. Why? Because this marriage officer will have to put this on the notice board that this particular lady and that particular gentleman, they want to get married under the Special Marriage Act. And if you have any doubts, if you have any problems, you come to us and register your doubt. Intention was good. Intention was, what if this man is already married in his village? Now he comes to the city, wants to marry this beautiful girl under the Special Marriage Act. She is so deeply in love that she is not even aware that this guy is already married. But once they want to get married under the Special Marriage Act, the marriage officer will have to put out a notice that this particular man and this woman, they want to get married. If you have any objections, please come to us. Maybe his first wife, their family, they will come to know and they will come and tell before the marriage officer that this person is already married. And if this person is already married, he cannot marry again without divorcing that girl first. Because if it was under the Sharia law, this person could have married 4 times. But if it's a Special Marriage Act, polygamy is not allowed. You can marry only once, unless and until you divorce the other person. So this was meant to be a protection for women. But in reality, what it is doing, boy and a girl, they want to get married under the Special Marriage Act because the girl wants to maintain her religious identity. The boy also wants to maintain her religious identity, because what has religion got to do with love after all? You want to get married and live happily ever after, but for that you have to give the notice period. That means 30 days later we will give you the time when the marriage would actually be registered. Till that time, whatever objections people will have, we will have to look at that. But now, when this notice is put out, if they are in love with each other, but it is an interreligious marriage or it is an intercaste marriage, that means the families of both these parties, they are not in agreement with this marriage. And when this notice is put out, it's like an open invitation to them. Please come with all your gundas and all your support and stop this marriage. Maybe kidnap the girl, maybe kidnap the boy, or maybe kill them. This notice period also violates privacy. And right to privacy is a fundamental right. but notice period is there. Allahabad High Court said there is no need to put out this notice, but that is only with respect to Uttar Pradesh. For the rest of the country, notice period is still valid. Not just this, Act stipulates that an application for marriage can be made only in a place where at least one of the parties resides, which means no runaway marriages. What does that mean? Boy and a girl, they are in deep love with each other. Boy is from Karnataka, the girl is from Tamil Nadu, right? They can't marry in Karnataka because the girl's family will kill. They can't marry in Tamil Nadu because the boy's family will kill. What they do, they come to Madhya Pradesh. Bulldozer Mama, we want to get married. The marriage officer says, but since you're not a resident of this place, we can't register your marriage. What you can do, you can stay here for 30 days. After 30 days, you can apply for marriage. So thank you so much. So we will somehow manage these 30 days in Madhya Pradesh. After 30 days, can we come and register for marriage? Yes, you can come. But at that time also, we have to send out a notice. Notice to whom? Notice to a Tamil Nadu court where the girl is from, and notice to Karnataka court from where the boy comes from. Sir, I don't understand. See, you are not a resident of Madhya Pradesh, neither the boy nor the girl. If you were a resident of Madhya Pradesh, you would just have to come, apply for marriage, and after 30 days, we will give you the date you can get married. But since you are not a resident of this place, we cannot allow your marriage. What you can do, you can stay here for 30 days. After 30 days, you come back, and we will give you a time of 30 days, after which your registration will take place. But in this 30-day period, I will have to send a notice to the court of a place where the boy comes from, to the court of a place where the girl comes from. Basically, to inform anybody in your home state, if you have any objections, please come and raise your objections. It basically means that through this notice, you're basically telling the family of the girl, family of the boy, log on to makemytrip.com, book your air tickets or train tickets or bus tickets, come to Madhya Pradesh and kill these two, because they have decided to do the unthinkable of marrying against the choice of their family. It violates privacy and also gives an open invitation for violence, so that their family members, they can use physical force to stop this marriage. If either of the party is not a permanent resident of the place, the act says that the marriage officer has to inform the court in the district within whose limit that party is a permanent resident. So imagine a situation if the boy and the girl belong to two different religions, and they thought that our love is sufficient enough, but we will still keep our religious identity intact. But when you look at these provisions, 30 days, sending notice to the district, sending notice on the notice board, the boy convinces the girl that you change your religion. Change your religion, embrace Hinduism, we can go to a temple and get married. Change your religion, become a Muslim, we can go to a Qazi and get the nikah done. So it is easier for people to convert to each other's religions rather than getting married under the Special Marriage Act, because the procedures are so cumbersome that it is not facilitating, but it is basically impeding marriage. Not just this. In effect, what this means is that marriage officers must send a letter to the permanent addresses of the parties, informing them that their son or daughter is about to do the unthinkable, exercising his fundamental right to marry someone of his or her choosing. And we will discuss today that now the court has said right to marry is not a fundamental right. Why did the court say this? We will discuss this slightly later. In practice, therefore, by making sure that parents as well as the caste or community leaders are aware of the time and the location of this marriage well in advance, So here the state becomes like a khap panchayat, so that the society gets to decide who gets to marry and when. Like the khap panchayats of Haryana, where they decide whether the couple can marry or not, whether the couple can stay in this district or not. You should not marry in the same gotra. If you do that, we will kill you. Indian state is behaving like the same khap panchayat. Not just this, you need to understand that this law was passed in the year 1954. Parallelly, what was also happening? 3 Hindu code bills were being drafted, debated, discussed, and passed. And at that time, Pandit Nehru was attacked by the Hindu right, the Orthodox Hindus, saying, why are you only touching the Hindu laws? Why not the Muslim laws or the Christian laws or the Parsi laws? You are anti-Hindu. Dr. Ambedkar also resigned. Now a concession was given to these Orthodox Hindus that you should support us. We have a concession for you. Because the argument against Pandit Nehru was, on one hand, you are codifying the Hindu laws, and on the other hand, you are hell-bent of converting our Hindu daughters into other religions. Because if you allow inter-religious marriage, the Hindu majority would become Hindu minority. You are facilitating inter-religious marriages. A concession was given. If a Hindu, which includes Sikhs, Jains, and the Buddhists, according to the definition, a Hindu is a Hindu, a Sikh, a Buddhist, a Jain as well. If a Hindu marries a non-Hindu, he or she cannot inherit ancestral property. So it was like a threat. You're a Hindu. Don't marry outside your religion. If you marry, then you will lose your ancestral property. It was like a threat. So an act which was meant to facilitate inter-religious marriage is now imposing such restrictions, not allowing a Hindu to marry outside her religion or outside his religion. If you do that, you will lose your ancestral property. Which basically means this provision, which applies only to Hindus, the law does not bother to punish Muslims or Christians in a similar manner. It seems that while the Indian Republic hates the idea of inter-religious marriages, because you are making it very difficult by having this notice period, by sending the letter to the district, by asking these people, come, log on to IRCTC website, if you ever find it working, book the train ticket and come, use force to stop this marriage. It seems that the Republic of India hates the idea of inter-religious marriage, but one involving a Hindu gives it a special heartburn. If a Hindu marries a non-Hindu under the Special Marriage Act, you will lose your ancestral property, basically forcing them not to have an inter-religious marriage. So what is the only alternative then? To convert into each other's religions, because then you can marry easily without having to satisfy these conditions under the Special Marriage Act. But under the Special Marriage Act, there is a requirement. The requirement is who can marry. One party has to be a man, the other has to be a woman. That means only a heterosexual relationship is allowed under the Special Marriage Act. The year was 2017. Navtej Johar versus Union of India. Supreme Court said right to love is also a fundamental right. Section 377, insofar as it criminalizes homosexuality, it is not a crime. LGBTQ relationship was approved. Gay relationships were approved. But then the logical conclusion would have been, the next step should have been, give them the right to marry as well. So if right to love becomes a fundamental right, if homosexuality is not a crime, if man and a man can be in a romantic and sexual relationship, if a woman and a woman can be in a romantic sexual relationship, then the next conclusion should be, give them the right to marry as well. Because Special Marriage Act says one party has to be a male, the other party has to be a female. So this requirement under the Special Marriage Act is discriminatory. When it is discriminatory, it should be struck down on the grounds of violation of Article 15, because there can be no discrimination on the ground of sex, and sex includes sexual orientation. Then the matter was before the court. A 5-judge bench of the Supreme Court had to decide that is the next step a logical next step. Because if you have right to love, does that also mean later on that you have the right to marry as well? You can marry the person of the same gender. Advocate Menaka Guruswamy argued that we would like to be recognized as full human beings. When we are full human beings, that means we should have the right to marry as well, just like heterosexual couples are allowed to marry. Yesterday, five-judge bench of the Supreme Court unanimously, that means through full consensus, Justice Chandrachud, Justice Kaul, Justice Ravindra Bhatt, Justice, two other judges were there. They said right to marry is not a fundamental right. It was a judgment that very few people expected. The expectation was that right to marry should be extended to the same-sex couples as well. Over a period of time, you will see a lot of articles being written on this matter where this judgment would be criticized, and rightly so. But for the civil services examination, what you need to understand is why court said what it did. They said right to marry is not a fundamental right. Unanimously, by 5-0. All the 5 judges said right to marry is not a fundamental right. Why? Because they said, look at Schedule 7 of the Constitution. It talks about union list, it talks about state list, it talks about concurrent list. Entry 5 in the concurrent list talks about marriage, which means both the parliament as well as state legislatures, they have the right, they have the power to make a law giving status to marriage or regulating divorce. Listen to me carefully. That means in distribution of powers into union list, state list, concurrent list, entry 5 of the concurrent list talks about marriage, divorce, which basically means both parliament as well as the state legislature, they have the power to regulate marriage and divorce in India. That means this matter can be dealt only by the act of legislature. What if the legislature does not want to regulate marriage? Nobody can force them. What if the legislature does not want to pass a law to regulate divorce? Nobody can force them. But if you equate right to marry to that of a fundamental right, that means if the state is not recognizing marriage, if the state is not legalizing marriage, you can drag the state to the court. This goes against Constitution. Because Constitution has spoken of distribution of powers in such a manner that on matters related to marriage, divorce, parliament and state legislatures, they can enact a law, and through their law they can decide how to regulate marriage, how to regulate divorce. They may not do that as well. They may not regulate it. They may not give it a legal status. They may not do anything. But if it's a fundamental right, it becomes mandatory for the state to regulate it. You can force the state to regulate it. But that is not how constitutional makers envisaged this marriage as an institution to be. Because they kept it not in fundamental rights, they kept it in distribution of power, Schedule 7. If it is a fundamental right, that means you can force the state to regulate it, but it is not a fundamental right. Point number one. Point number two, court said there is theory of separation of powers, where we have three different organs. We have executive, we have legislature, we have judiciary. And all the organs perform their own unique functions, and no organ can perform the function of the other organ. That's what separation of powers is. Dr. Justice Chandrachud said that there is theory of separation of powers, where we have three organs: legislature, whose job is to make laws; executive, whose job is to run the government, to run the affairs of the state, to implement the laws; and judiciary, whose primary job is to decide whether the laws are constitutional or not, to punish people for violating the laws. No organ, according to this separation of powers, can take up the powers of another organ, can use the powers of another organ, can acquire the powers of another organ. That is something that we can't do. So when we look at Special Marriage Act of 1954, can this law be challenged? Yes, because that's the power of the judiciary. Judicial review is part of the basic structure. What is our position? Either we can declare the law as unconstitutional, or we can add something or remove something to make it constitutional. What is the job of the judiciary? 5 judges had to decide whether same-sex couples have the right to marry as well, whether they should be allowed to marry as well, whether they can adopt children as well. Question number 1, the Supreme Court said right to marry is not a fundamental right, and a unanimous verdict. Despite the fact that in previous judgments, Supreme Court had said, as recent as Shafin Jahan case, where the Supreme Court had said right to marry is a fundamental right. It's under Article 21 of the Constitution. In fact, this question was asked in the prelims examination as well. Right to marry comes under which of the articles? Article 21 of the Constitution. Despite that, although it was a judgment given by 2 judges in the Shafin Jahan case, now 5 judges unanimously are saying right to marry is not a fundamental right. Why? Because if fundamental rights are violated, you can drag the state to the court. That means if your right to marriage is violated, you can drag the state to the court. But state, which is the legislature, which is the parliament and state legislatures, they have been given the power, the procedure that you can regulate matters related to marriage and divorce. What if they don't want to? But if it's a fundamental right, you can force them to interfere. What if they don't want to? That is why constitution makers did not deem marriage to be elevated to the status of a fundamental right. It is not a fundamental right. Second, the court said judicial review is part of the basic structure. Yes, it is. Can we review any law passed by the parliament? Yes. So this section, Special Marriage Act, which places a requirement and eligibility that only a man and a woman can marry, that means only recognizing heterosexual relationships. Now this was challenged, that since it does not allow homosexuals to marry, it does not allow the persons belonging to the same sex to marry, it is discriminatory in nature. Court said, look at separation of powers. We can do what is our role. Legislature can do their job, executive can do their job. We cannot take away the powers of the legislature. We cannot control the powers of the executive. We cannot snatch each other's powers. We cannot play each other's roles. Judiciary cannot play the role of the legislature. But what if a law is passed by the legislature? Either we declare that this law is unconstitutional, but we cannot declare Special Marriage Act as unconstitutional. Why? Because if we do, we will go back to pre-independent India. And what happened in pre-independent India? A couple belonging to two different religions, if they have to marry, they have to give up their religion. They have to renounce their religious identity. If we declare Special Marriage Act as unconstitutional, what will happen to the heterosexual couples of two different religions? If they want to get married, they have to give up their religion. We can't do that. That is why we can't say Special Marriage Act is unconstitutional, because it would deprive others of their rights. But what we could also have done, we could have added something to this law to make it constitutional. We could have removed something from this law to make it constitutional. So if the requirement is that you have to be a male and a female to get married under the Special Marriage Act, we would have removed this and we would have said person of any gender can marry. That means we can add something, we can remove something to make it constitutional. This is also something that we will not do. Why? Because if we do this, it amounts to judicial legislation. And judicial legislation is oxymoron. They're not compatible with each other. How can judiciary legislate? That would be violation of separation of powers. Because one organ cannot take away the powers of another organ, take away the role of another organ, perform the role of another organ. If we add something to this law to allow LGBTQ community to also marry, if we remove something from this law saying no, a person of opposite sexes alone can marry, we should remove this and say person of any gender can marry, this would amount to judicial legislation. This would violate separation of powers. That is why we will not do this. Let Parliament take a call. If Parliament wants, and Parliament, according to Justice Chandrachud, Parliament gets wisdom from various sources. These parliamentarians, they interact with the people, they interact with the society, they interact with the intelligentsia. So they have enough information, if enough insights, and if they want, they can change the law. But we will not do this because this would amount to judicial legislation. But then two judges, the other part of this verdict was split into 3:2. 3 judges said no, 2 judges said yes. Who are the 2 judges in minority? Justice Chandrachud and Justice Sanjay Kishan Kaul. Minority judgment. The remaining 3 judges, they had a different take on this matter. And what is this matter? Let's discuss. But first, it is rare for a Chief Justice to be part of the minority judgment. Why? Because Chief Justice sets up the bench. So all the 5 judges on this bench were chosen by the Chief Justice himself. And when Chief Justice sets up a bench, Chief Justice would also ensure that majority of these members, they side with his opinion, with his verdict. But here Chief Justice was in the minority, which is rare. But previously it happened when Justice UU Lalit, as the Chief Justice of India, he was in a minority judgment when it comes to the EWS reservation. When EWS reservation judgment was given, his opinion was also in the minority, which is rare. But what was the difference? What was the differences of opinion? Juvenile Justice Act and the CARA rules. There are rules which talk about adoption. Who can adopt a child? For that, there is an institution known as CARA, and there is a law known as Juvenile Justice Act, which talks about adoption. Who can adopt a child? Heterosexual couple. Only a heterosexual couple who are in marriage and they have been married for at least 2 years, they can adopt a child. Homosexual couples cannot. Those who are not in marriage, they cannot. The other question before the court was these rules are discriminatory against the members of the LGBTQ community because they can't adopt a child. Because the CARA rules, the Juvenile Justice Act, prohibits homosexual couples from adopting a child. Justice Chandrachud and Justice Kaul said these rules are unconstitutional because they are discriminatory against LGBTQ community. They are violative of Article 14. Article 14 talks about listen to me carefully. This is a beautiful argument, which also becomes fodder for criticism against the Chief Justice himself. And I'll tell you why. Intelligible differentiator. That means what under Article 14 state can do? State can group some people together and exclude others. Just like in Citizenship Amendment Act, Muslims separately, Hindus, Christians, Buddhists, Jains, Parsis, Sikhs were separately. That means you are differentiating between two classes of people. But when you are differentiating, there has to be reasonable nexus. With the objective that you want to achieve. If you can classify people into different groups, you can do that, provided this classification you are doing because you want to achieve one object. You want to achieve some objective. In Citizenship Amendment Act, what is the objective? What is the rational nexus with the objective? You are classifying people on the grounds of religion. Minority separately, majority community separately. Why are you differentiating between the two? Because you want to achieve an objective, which is to provide citizenship. So there is a nexus between classifying people and the objective. Why did Juvenile Justice Act? Why did CARA rules talk about and differentiated between heterosexual couples and homosexual couples? Can you classify people into two groups? You can, provided it has a nexus with the objective that you want to achieve. What is the objective? Safety, development of child. Growth of the child. We want to classify people into two groups, those who are married, those who are unmarried. Those who are homosexuals, those who are heterosexuals. Why are we differentiating them? What is the intelligible differentiator? Because we want to achieve an objective. What is the objective? Because we want to ensure safety, growth, and development of a child. Only a stable family can provide growth and stability to the child. That is why we have to divide families into married and unmarried families. Justice Chandrachud, Justice Kaul said, does that mean only a heterosexual couple can give safety, growth, and development to the child? If that is the objective, you are with the assumption that a homosexual couple cannot ensure growth, development, and the upliftment of a child. Which means if you are differentiating between homosexual couples and heterosexual couples, with this mindset, with this assumption that only a heterosexual couple can give growth, development to a child, this is illogical, violates Article 14. That is why these rules are unconstitutional. Now, homosexual couples, you can also adopt. But three other judges said, no, they can't adopt. When they are not married, that means there is no stability in the family. Because at any point in time, one partner can come out of that relationship. There is no stability in this relationship. Ultimately, you cannot adopt as well. Only the heterosexual couple can adopt. Yes, all these LGBTQ community members, they have a right. They can live with their partner. That right comes under Article 21 of the Constitution, which talks about right to life and personal liberty. Although Justice Chandrachud disagreed, Justice Chandrachud said this right is under Article 19. Article 19 talks about union, association, cooperative society. So a union of two gay couple, of a couple belonging to the homosexuals, a homosexual couple can also form a union. Three other judges said, no, this is not under Article 19, this is under Article 21, right to life with dignity, with personal liberty. You can live with your partner in your home. Nobody should disturb you. Nobody should challenge you. In fact, what we will do, we will set up a committee. Or the government should set up a committee headed by the cabinet secretary. And this cabinet secretary headed committee should decide, should sensitize states and union territories that you should not discriminate against LGBT community. This committee should decide what are the safeguards, what are the other benefits that can be given to LGBTQ community. But so far as right to marriage is concerned, right to marriage is not a fundamental right. So far as allowing same-sex people to marry under Special Marriage Act, we can't strike down that law. That's the job of the parliament. So far as whether same-sex couples can adopt the child, three judges said no, they can't adopt the child. Although two judges disagreed, including the Chief Justice. That is the verdict given by this 5-judge bench of the Supreme Court yesterday, which completes our discussion on directive principles of state policy. Let me know. If they want to live with dignity and for their dignity, marriage is important. So is that not violating Constitution when it says marriage is not a fundamental right? What is Constitution? After all, Constitution is what the judges say it is. Even Justice Chandrachud is wrong when he says right to marry is not a fundamental right because that would amount to judicial legislation. But when inherent in your law there is discrimination, isn't right against discrimination a fundamental right? So on the grounds of discrimination, it should have been struck down. Forget about saying whether right to marry is a fundamental right or not. Even a normal law cannot violate your fundamental rights. So if your Special Marriage Act, which lists a condition saying one of the party has to be male, the other has to be female, let's assume for a while right to marriage is not a fundamental right, but this provision is discriminatory. It violates Article 15, which talks about non-discrimination on the ground of sex and sexual orientation. Since this rule is discriminatory, isn't the Supreme Court guardian of your fundamental rights, protector of your fundamental rights, protecting your Article 15? So on Article 15 ground, it should have been struck down. Plus, there is something known as non-retrogression of rights. Sir, if in 2024 prelims question is asked right to marriage is a fundamental right, what will be the answer? The answer is no, it's not a fundamental right, because what is the recent situation? It's not a fundamental right. Non-retrogression of fundamental rights or non-retrogression of rights. That means once rights are given to you, these rights can only be enhanced. They cannot be snatched. So when the 2-judge bench of the Supreme Court said right to marry is a fundamental right, the Supreme Court should enhance it. It should not take it back. When we say there can be no discrimination on the ground of sex, And the same Justice Chandrachud in Joseph Shine case, in Navte Johar case, said sex means sexual orientation as well. On sexual orientation also there can be no discrimination. Why did you in your judgment discriminate on the grounds of sexual orientation? That is why you should read today's Indian Express, and there's a brilliant editorial, but an even brilliant column written by Pratap Banu Mehta. Absolutely fantastic, and the way he is very politely criticizing the Chief Justice and the Supreme Court, that's worth your time. Once the class is over, please read that column. Then right to marriage comes under which right? It's a statutory right provided by the law passed by the parliament. Earlier judicial legislation happened or not? Yes. We'll discuss tens of judicial legislation cases in judiciary. Today's newspaper, sir? Yes, today's newspaper. Could we consider setting the legal age for marriage at 25 as an alternative to Special Marriage Act? This age signifies a level of maturity where individuals can make informed decisions regardless of their religious background, thus reducing the risk of religious conflicts. This is like democratic or undemocratic paternalism. You're patronizing people. You are old enough to vote at the age of 18. You are old enough to be hanged when you are of the age of 18. Why should for marriage there be a different age criteria? And today, children, they mature faster. They can take a good decision at the age of 16 itself. Both are important decisions. Through voting, you choose a government which is going to interfere with the most intimate details of your life as well. Isn't that also an important decision that you make? It may be increased. There is a bill for that, to raise the marriageable age for women to 21, same as that of boys. Whether that will happen or not, we'll have to wait and see. Was married to Prakash Kaur. Under the Hindu laws, he could not marry again unless and until he divorces his wife. But he falls in love with Hema Malini, dream girl, decides to convert to Islam and get married. Duties, powers, that is the job of the parliament. If the parliament through law wants to provide legal status to this marriage, they can do that. Were originally not part of the constitution. This part was added, this part 4 capital A was added by the 42nd Constitutional Amendment Act 1976. Initially, there were 10 fundamental duties provided under Article 51 capital A, but later one more fundamental duty was added in 2002. So in total, we have 11 fundamental duties. What is the background? These duties, which were added by the 42nd Constitutional Amendment Act in the year 1976, such duties you won't find in modern liberal constitutions. For example, the Constitution of the United States. Because these constitutions focus on rights and not duties. What are rights? Rights are basically limitations on the powers of the state. So these Western liberal constitutions, such as the United States Constitution and others, they emphasize more on how do we limit the powers of the state so that state does not interfere with the life and liberty of individuals. So they place more emphasis on rights, which are limitations on the state, rather than emphasis on duties of citizens towards the state. They want state to be restricted rather than the citizens. But when Indian constitution was enacted, there were many who felt dissatisfied with the constitution. For example, Mr. P.V. Kane, who later on was awarded Bharat Ratna as well, India's highest civilian award. He writes in the History of Dharmshastra's Volume 5 that I'm not satisfied with our constitution. He was critical of the constitution. He said our constitution is like the constitution of the West, blindly aping these Western constitutions, only emphasizing on the rights and not on duties. But as Indians, as cultural people, we have duties towards our fellow human beings. We have duties towards our parents. We have duties towards our teachers. We have duties towards our environment. All these important aspects of duties, they are negated, set aside, unattended by this constitution. And our constitution is blindly following the Western constitutions, which is blindly focusing on rights rather than duties. The objective of these duties is to make people responsible. Responsible why? Because a committee was set up in 1976, headed by Sardar Swaran Singh, who was then the External Affairs Minister. Sardar Swaran Singh was asked by Madam Gandhi was the Prime Minister, you advise, recommend, and tell me a list of fundamental duties that we can mention in our constitution, these fundamental duties that will be applicable to the citizens. Madam Gandhi was asked, why is there a need to add this chapter, fundamental duties, to the constitution? She said, Indians and the citizens of India, they are very aware of their rights. Right to property, right to equality, right to freedom of speech and expression. They're always cribbing about rights. I want to make them aware of their duties as well. And that is how in 1976, Sardar Swaran Singh Committee was set up. It gave its report. Some of the recommendations were accepted, some were not accepted. But then this Sardar Swaran Singh Committee became the basis on which constitution was amended for the 42nd time in 1976, and 10 fundamental duties were added. Later on, one more fundamental duty was added by 2002 86 Constitutional Amendment Act. So in total, we have 11 fundamental duties. And you have to memorize all the 11 fundamental duties. Why? Because sometimes the question is asked, which of the following are directive principles? And there are some DPSPs which match in language with fundamental duties. There are some fundamental duties which resemble some directive principles. So you have to be absolutely sure which one is a DPSP, which one is a fundamental duty. And for that, the best solution is remember all the fundamental duties, all the 11 fundamental duties. And it is not difficult to remember because I will give you a trick. What is the trick? Let's say you're preparing for the civil services examination and you want to clear this exam, but you want to become an IPS officer, Indian Police Service officer. And once you are appointed, over a period of time, you become a Senior Superintendent of Police, SSP. Manisha, isn't it like Koshal judgment where judiciary found it easy to transfer the responsibility to the legislature? Absolutely, you're right. It's like putting the ball in the court of the legislature, telling them, you decide what you want to do, we will not interfere. So let's say you are appointed as the Senior Superintendent of Police, but you are very corrupt as well. And suddenly, one fine morning, you're having coffee, there's a knock at the door. Who is it? We are from Anti-Corruption Unit. You are under arrest. I said, what rubbish? How can you arrest me? What is the proof that you have? They will show you a DVD where it is shown how you are taking bribe, exchanging money, so on and so forth. Ultimately, what will you do? You will call your journalist friends, please don't publish this news. I'll be back soon, but don't publish this news. Don't broadcast this news. If you're good with Arnab Goswami, you will tell him, please don't say nation wants to know why this SSP was arrested. because nation clearly doesn't want to know. And plus, take this money and don't use nation in your argument. In corporate language, we call it PR, public relations. And ultimately, what will happen? You will win. One, two, three, 4, 5, 6, 7, 8, 9, 10, 11. These are the 11 fundamental duties. What are these 11 fundamental duties? To strive towards excellence in all areas of human endeavor. What is another S? To safeguard public property and to abjure violence. What is P? To protect and improve natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. What is A? To abide by the Constitution, respect its ideals, the national flag, and the national anthem. What is C? To cherish and follow the noble ideals which shaped our struggle for freedom. What is U? To uphold unity and integrity of India. What is D? To defend the country and render national service when called upon to do so. What is V? To value and preserve the rich heritage of our composite culture. What is D? To develop scientific temper, humanism, and spirit of reform. What is P? To promote harmony. And what is R? And renounce practices which are derogatory to the dignity of the woman. And what is W? A fundamental duty is imposed on your parent, on your guardian, that for your ward, for your child, you have to ensure educational opportunities for all the children in the age group of 6 to 14. These are the 11 fundamental duties. Using this acronym, SSP, ACU, DVD, PRW, you will be able to memorize all the 11 fundamental duties. But memorize you must, that is important for your exam. But now, let's look at some of the important points vis-a-vis fundamental duties. We have borrowed these duties from USSR Constitution. But now there is no USSR because USSR got dismembered in the 1990s. It broke away into various independent countries. So now we don't have a USSR constitution. If there is any other democratic country where there is a fundamental duty, that is the Japanese constitution. Japanese constitution, apart from Indian constitution, also talks about fundamental duty. But there are some international covenants, international agreements, such as Universal Declaration of Human Rights and International Covenant on Civil and Political Rights. They also talk about duties. So they talk about what is the duty of an individual vis-a-vis the state. What is the duty of an individual vis-a-vis fellow individuals? You should not deprive liberty of others. You should not go against the state. You should not wage war against the state. So Human Rights Declaration, International Covenant on Civil and Political Rights, they also talk about duties that the individuals will have towards the state. But you need to understand that these are exclusively available to citizens. And no mandamus can be issued. What is this no mandamus can be issued? When we discussed Article 32 yesterday, what did I tell you? That mandamus can be issued by the Supreme Court against whom? Against a public body. If this public body has failed to perform its duty, then you can approach the Supreme Court. Supreme Court can issue the writ of mandamus saying we command you perform this duty and ensure fundamental rights of the petitioner. But when we talk about duty, it's a public duty of a public body. You cannot approach the court and say that since we have fundamental duty and this particular citizen is not abiding by the fundamental duty, you issue the writ of mandamus to force this private citizen from abiding by fundamental duty. You can't do that. Why? Because it's not a public duty. And at the same time, this fundamental duty chapter is not enforceable, although Parliament can prescribe punishment for those violating fundamental duties. Listen to me carefully. Fundamental duties under Part 4, capital A of the Constitution. Part 3, Part 4, Part 4, capital A. Although these are distinct parts, separate units, yet taken together, what do? They concretize, they give shape to the lofty ideals which are mentioned in the preamble of the Constitution, which is justice, liberty, equality, fraternity, dignity of an individual. Fundamental rights are limitations on the state for the promotion of political democracy. Directive principles are positive obligations of the state for the promotion of social and economic democracy. Fundamental duties are to ensure that we create a sense of fraternity, where we belong to the same common land, where we are good to each other, where we have duties towards the state and towards the fellow human beings as well. But fundamental duties were not originally part of the Constitution. The Constitution was amended in 1976 through 42nd Constitutional Amendment Act based on the recommendations of the Sardar Swaran Singh Committee. Initially 10, later on one more. So total 11 fundamental duties are there in the Constitution. And you have to memorize all the 11 fundamental duties. For that, there is an acronym: SSP, DVD, ACU, SSP, ACU, DVD, PRW. But then these fundamental duties are not legal duties. If it was a legal duty, then if you violate fundamental duty, you could be arrested. But fundamental duties are not legal duties. When it is not a legal duty, that means you cannot be arrested for violating these fundamental duties. Further, no mandamus can be issued by the court. Court cannot issue the mandamus saying we command you perform this fundamental duty, because it's not a legal duty. It's not a public duty either. Mandamus can be issued only against a public body when that public body is failing to discharge its public duty. And it is exclusively available to the citizens, and the very purpose is to ensure that citizens become educated. But sir, then if I denigrate the national flag, if I throw national flag upside down or burn it, will I not be arrested? I will be. If I disrespect the national anthem, will I not be arrested? I will be arrested. Why? Not because you are violating fundamental duty, but you are violating Prevention of Insult to National Honor Act. There is a law passed by the Parliament in 1971 known as the Honor Act, under which if you disrespect the national flag, the national anthem, you can be arrested. So if you are disrespecting the national flag and the national anthem, you're not arrested for violating fundamental duty. You're arrested for violating this law. Because fundamental duties, they are not enforceable in a court of law unless and until Parliament prescribes as a punishment for violating these fundamental duties. That means Parliament can enforce some of these fundamental duties by passing a law. Similarly, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for wildlife, compassion for living creatures. Does that mean you can kill a tiger? You can't, because that's a protected animal. You will be arrested. Does that mean you can pollute the rivers? You can't do that because you will be arrested. Does that mean you will be arrested for violating fundamental duty under Article 51, capital AG? No. You will be arrested because you are violating the law passed by the Parliament. Wildlife Protection Act, Pollution Control Act. For such acts, you can be arrested. For violating such acts, you can be arrested. Similarly, to safeguard public property and to abjure violence. What if you destroy public property? What if you commit violence? That doesn't mean you are arrested because you have violated fundamental duty. You are arrested because you violate the Indian Penal Code. That is why we say these fundamental duties on their own, they're not enforceable in a court of law because these are not legal duties. Which means even if you violate them, even if you don't follow them, no action can be taken against you. Except if you violate the law passed by the Parliament. Because there are some laws passed by the Parliament, which if you violate, you will be arrested. And some of these laws ensure that you respect fundamental duties. You abide by fundamental duties. Some laws enforce fundamental duties. But there are some who criticize this whole chapter, saying, very important, duties are missing from this list. For example, paying taxes on time is not a fundamental duty. Family planning, where India is now the most populous country of the world, is not a fundamental duty. Duty to vote in the elections is not a fundamental duty because the date on which voting takes place, we treat it as a holiday. So important things such as family planning, duty to pay tax or duty to vote, these are not considered fundamental duties. These are not fundamental duties. But some vague ideas are. What are these vague ideas? To cherish and follow the noble ideals which inspired our national struggle for freedom. Which are these noble ideals? Because if you talk to different people, they will give you different reason for independence. If you talk to a communist, they will say we got independence because of the Royal Indian Navy mutiny which took place. Otherwise, Bapu and Pandit Nehru and Sardar Patel, they had almost sold this country. We would have never got the independence. If you talk to a Gandhian, they would say Mahatma Gandhi, it's because of Mahatma Gandhi that we got independence. If you talk to someone else, they would say it is because of Veer Savarkar that we got the independence. So what are these noble ideals which inspired our national struggle for freedom? We would not know. These are vague ideas. And there have been instances where the government is violating fundamental duties. Fundamental duty says to develop scientific temper. Whether right or wrong, if you look at science, if you look at religion, these are separate things. But the Prime Minister says plastic surgery was done during the ancient India as well. Because look at Lord Hanuman. Those who believe in objectivity, those who believe in science, they say Prime Minister should not have made this statement because it goes against fundamental duty, which is to develop scientific temper. What can we tell our kids? That plastic surgery is not a recent phenomena. It is something which was developed by Indians during the ancient period. Superstition. When a former chief minister of Karnataka, he did not enter his own house. Why? Because that was not Vastu compliant. Is that scientific temper? A new legislative assembly complex is developed in a state, but that legislative complex is not being used. Why? Because whoever enters that legislative assembly loses the power. In fact, there is one door at the legislative assembly in Karnataka which has been closed or which was closed Because when that door was open, the same government will lose the power. That was the assumption. That was the belief. But thankfully, Siddaramaiah, the current chief minister, he's a rational person. The first thing that he did, he opened that door and said, I will see who will remove me. So when the government, when the leaders in power, they speak of superstition, they speak of other ills, then you are basically not inculcating scientific temper in the minds of the kids, which is a fundamental duty. That is the criticism of this fundamental duties chapter. In fact, once a judgment was given by the Supreme Court that whenever you go to a multiplex, you go to a cinema to watch the movie, first, for 52 seconds, national anthem will be played, and all of you will have to stand up. National flag will also be displayed prominently. After that national anthem is played, then the movie can start. So it was like force feeding. Patriotism. Why did the Supreme Court say, why did the Supreme Court not say, whenever we will hear a case, first we will get up, remain standing for 52 seconds, listen to the national flag, and then sit down? Why did the Supreme Court not say national flag should be played in the parliamentary proceedings every day? Why specifically with movies? Because you get enough attention quickly. Movies are not there. You don't go to a movie to become a patriot. You go to a movie to enjoy. It's like force feeding democracy. And the argument given was, if you can wait for 52 days or 52 hours standing outside an Apple store in Mumbai or Delhi to buy the latest iPhone, can't you stand for 52 seconds for the national anthem? These are not comparable. On one hand, you are doing it voluntarily. On the other hand, you are doing it through force. Force and democracy, they don't go hand in hand. There is no force in democracy. But fundamental duties, this chapter has come under criticism, a lot of criticism, because the real good fundamental duties are absent, missing, and some vague ideas have been included into fundamental duties chapter. That is all that you need to know regarding fundamental duties. Any questions? Let me know. If the tiger attacks you, even in your self-defense, you can't kill a tiger because you can't win against him. Unless and until you have a weapon which you can use to kill the tiger. In that case, under self-defense, you can kill anybody. Can you say directive principles which are mentioned in the Constitution but cannot be enforced in a court of law, are these legal principles? No, because they are not enforceable in a court of law. 1954. It's not that it's an outright foolish act. Every law would have some loopholes, would have some shortcomings. And that is how you iterate and over a period of time make it a better law. Unfortunately, we have not made it a better law. What if I kill anybody and say it was a self-defense? Prove it beyond reasonable doubt, then you are safe. Can High Court bench change another High Court bench decision, provided the next bench, which has to overrule the previous bench, it is of higher strength? If the previous judgment was given by 2 judges, they should be given by 3 judges or more. Okay. Was an eventful year in the history of independent India. In 1973, Karnataka as a state emerged. Mysore became Karnataka, or Mysore was renamed as Karnataka. 1973, Bollywood gave us its first chocolate hero. Rishi Kapoor made his debut in the movie Bobby. And who would have thought that this chocolate hero or good looking guy would perform roles such as the one he performed in Kapoor and Sons, the one he performed in Agnipath as what was the name of his character? Rauf Lala. Who would perform such a villainous role? It basically means it was the director's fault not to give Rishi Kapoor good roles. But what a fantastic actor he was. 1973 was also a year when somebody spoke of what if I kill a tiger. Steps were taken to save Tiger. Project Tiger was launched in 1973. And particularly significant is the date 24th April 1973, when Sachin Tendulkar was born. The man who saved India's cricket was born. But for our examination, 24th April 1973 is significant because on this date, Keshavananda Bharati judgment was given. A case which saved India's democracy. And the principal question before the court was, is the power of Parliament supreme that it can amend any provision of the Constitution? Is there any limitation on the amending powers of the Parliament? This judgment was given by 13 judges. Which is the highest till now. This case was heard for 68 days, which again is highest. This case runs into 703 pages judgment, which again is a lot. When Attorney General presented his case, he compared the constitutions of more than 60 countries of the world, telling the Supreme Court this is how in other countries constitution is amended. So this is considered to be the landmark case in the history of independent India, where the principal question that the Supreme Court had to answer was, is the power of Parliament supreme that it can amend any provision of the Constitution? But to understand what happened on this beautiful day, 24th April 1973, we have to go through history. And for that, we need to first understand what is the need to amend the Constitution. And what is constitutional amendment after all? Changing anything in the Constitution is a constitutional amendment. Adding a line, deleting a line, adding a right, deleting a right, adding a full stop, a comma, making any change to the Constitution is a constitutional amendment. But why should Constitution be amended? Pandit Nehru gave an answer. What is the definition of the Constitution? Constitution is the document of people's faith and aspirations. Aspirations keep on changing. What were the aspirations of the people in 1950? Those are not the aspirations of the people in 2023. And those will never be the aspirations of the people in 2053. So can this document remain static? Not subject to change? Unwilling to change? If it is unwilling to change, then it is just like a religious text which cannot be altered, which cannot be changed, even if the times keep on changing. That is why Pandit Nehru said this constitution has to be a living document. It should breathe. It should change. It should keep on changing based on the changing requirements of the time, based on the changing needs of the people. Any popular demand for changing the system should be capable of realization. Any popular demand. What if the demand of the people is the right to marry should become a fundamental right? If not 2023, because we are still homophobic, what if in 2053, when the people would become more acceptable to the changing realities of the time? In 2053, maybe right to marry is a fundamental right. Any popular demand should be capable of realization, should be capable of being implemented. That is why Constitution cannot remain static. It should not be static. It should be a living document. Dr. Ambedkar had a different take, a similar yet different. What did Dr. Ambedkar say? I am sure that most of you or some of you are not satisfied with the Constitution I have created. And it's okay, because I can't satisfy 100%. But if you are dissatisfied with this constitution, what you need to do, contest elections and get two-third majority in the parliament. And through this two-third majority, you can change the constitution. Or if you're dissatisfied with the constitution, get two-third majority in the parliament and alter the constitution. If you can get two-third majority, you can change the constitution. If you cannot get two-third majority, we can safely assume that only you are dissatisfied with the constitution. Your dissatisfaction with the constitution is not shared by the general public. Because if it was shared by the general public, you would have got the two-third majority in the parliament. Because after all, parliamentarians are elected by people. So one, constitution has to change depending upon the changing realities. Constitution has to be a living document. Any popular demand should be capable of realization. And for that, what you need to do, get two-third majority in the parliament and change the constitution. Which means if we look at the wordings, the statements given by Pandit Nehru and Dr. Ambedkar, anything can be changed in the constitution. All you need to do, get two-third majority and change the constitution. Anything can change. Everything can change, subject to the majority in the parliament. And for that, we have something known as Article 368 of the Constitution. Article 368 talks about the procedure that you can follow, Parliament can follow to amend the Constitution. A bill should be introduced in Parliament. Bill is a proposal that we want to change the Constitution, we want to amend this part, we want to add a fundamental right, we want to add a schedule, we want to add a part. That's a bill, that's a proposal. Get it passed by both houses of the parliament by two-third majority. Get it signed by the president. And then constitution stands amended. That is mentioned in Article 368. The year was 1951, Shankari Prasad Deo versus Union of India, 1951. What was the case all about? When Champak Dore Rajan said that fundamental rights are superior, directive principles are inferior. When Patna High Court said Land Reforms Act is unconstitutional, Zamindari Abolition Act is unconstitutional, how did the parliament respond? By amending fundamental rights, by modifying fundamental rights, by amending the constitution, by providing articles 31A, 31B, by providing 9th schedule of the constitution. The question before the court was, my lord, Article 13 is violated. The court asked how. Sir, look at Article 13, Clause 2. The state cannot enact any law to delete a fundamental right, to abridge a fundamental right, to modify a fundamental right. And what Parliament has done? First Constitutional Amendment Act, 1951, Parliament has amended fundamental rights. It has modified fundamental rights. It has imposed restrictions on fundamental rights. This is not the power available with the Parliament. But the Government Attorney General said, sir, there is a difference. Article 13, Clause 2, yes, it says Parliament or state cannot enact any law to delete, modify, abridge a fundamental right. But 13, Clause 3 also talks about the definition. What is this law? Law means order, act, rule, regulation, customs, bylaws, usages. The law under Article 13, Clause 3 is not the same as Constitutional Amendment Act. Law is different, Constitutional Amendment Act is different. Through a law, you cannot delete, modify fundamental right. But through a Constitutional Amendment Act, you can delete, modify, abridge a fundamental right, which means Parliament can do anything. Delete a fundamental right, add a fundamental right, maybe delete the entire chapter of fundamental rights. Supreme Court said it's completely fine. Shankari Prasad Deo versus Union of India, 1951. The word law does not include an amendment to the Constitution under Article 368. So when through law you cannot delete, modify, abridge fundamental right, But through Constitutional Amendment Act under Article 368, you can delete, modify, abridge. This was 1951. Just 16 years later, in Golaknath versus State of Punjab, Supreme Court did a complete U-turn and said fundamental rights are beyond the amending powers of the state. You cannot dare modify, amend fundamental rights. Sir, how can you say this? Look at Article 13, Clause 2. It says the state cannot make any law. When we say any law, that means includes a Constitutional Amendment Act. Because Constitutional Amendment Act is a law after all. When Article 13 says state cannot make any law to delete, modify, abridge fundamental right, Parliament cannot amend fundamental rights. This judgment was given by 11 judges. Rights are beyond the amending powers of the state. You cannot modify, abridge, amend it. Never. But in Golaknath case, the court was told, but sir, does Parliament not have the power to amend fundamental rights? Then what is Article 368 after all? It talks about the power of the Parliament to amend the Constitution, and Constitution includes fundamental rights. Through Article 368, we should do that. We can do that. We should be allowed to do that. The court said, who told you that Article 368 talks about power of the Parliament to amend the Constitution? It does not. Read Article 368. The very title of Article 368 talks about procedure for amending the Constitution. It does not talk about power of the Parliament to amend the Constitution. The court was asked, then how can we delete a fundamental right? Okay, forget about deletion. What if tomorrow we want to add a fundamental right? We should be allowed to do that. I said, no, not you. Set up a constituent assembly, and that constituent assembly should use the procedure under Article 368 to add a fundamental right, to modify a fundamental right. You, Parliament, you can't do that. Because in this case, what Supreme Court said is that Parliament has broadly two types of powers. One is an ordinary law-making power. The other is a constituent power. What is an ordinary law-making power? Parliament can make a law on any item mentioned in the union list. That means for citizenship, for extradition, for banking, for insurance. That's the power available with the Parliament, making ordinary laws. But then there is a constituent power. Constituent power means the same constitution has created the Parliament. And Parliament has the constituent power. That means it can act as a constituent assembly and modify the constitution, amend the constitution. Golaknath case, Supreme Court said, how can this constitution, which has created the legislature, how can we say that this legislature, which was created by the constitution, has the power to change the same constitution? No, you can't do that. You set up a different constituent assembly. Let that different constituent assembly amend the constitution. This Parliament, you only have ordinary law-making power, not the constituent power. Don't you dare amend fundamental rights. When this judgment was given, Constitution was amended again. 1971, 24th Constitutional Amendment Act, but the first thing that was done was, whenever a constitutional amendment bill is sent to President shall give assent to that bill. We will discuss in the President that President has some powers known as veto powers. When a bill is presented to President, he may say, I don't want to sign this bill. President may return that bill. Whatever. But Indira Gandhi was the Prime Minister. Parliament amended the Constitution. and said whenever a constitutional amendment bill is presented to the president, he has only one option: sign it. No other option. Some other changes were made. Article 13 was amended, Article 368 was amended. Article 13, where we discussed Article 13, Clause 4 was added. Nothing in this article shall apply to an amendment of the Constitution made under Article 368. Nothing in this article. That means this article says state cannot make any law to delete, modify, abridge fundamental right. Now the Constitution is amended. Article 13, Clause 4 is added to say that this restriction does not apply to a constitutional amendment. That means through a constitutional amendment, you can delete, modify, abridge fundamental right. And Article 368 itself was amended. Article 368 said, power of the parliament to amend the constitution and the procedure therefore. That means previously the title was procedure for amendment of the constitution. Now the title of Article 368 itself has been changed to power of the parliament to amend the constitution and the procedure therefore. This was another change. That means fundamental rights were modified. Something else happened. We have discussed today in DPSP through 25th Constitutional Amendment Act 1971, Article 31 capital C was added, where 2 DPSPs were given superiority over 3 fundamental rights, which means 3 fundamental rights were modified, their impact was modified. Another change to fundamental rights. 26th Constitutional Amendment Act was passed, privy purse was abolished, which means right to property was violated, right to equality was violated. These changes took place. And then a landmark case, Kerala Land Reforms Act. The Kerala legislature, which was dominated by the communists, they enacted a law and said there are these private colleges, we can regulate their curriculum as well. For that, they had passed a Kerala education bill. That was their first step towards ensuring that on these private educational institutions, state will exercise control. But then they went a step further. They passed a law calling for land reforms, saying we can acquire land and distribute this land, even if this land belongs to religious communities. Even if this land belongs to religious communities, we can acquire this land and distribute this land. Somebody told Kerala government that it violates fundamental rights. Don't do that. This law will be struck down. Kerala government said, but we want to do this. What should we do? Said, request parliament that place this Kerala Land Reforms Act in 9th schedule. And any law which is placed in 9th schedule is immune from judicial review. The government of Kerala approached the parliament, approached the central government, requested the central government to please place this law in the 9th schedule. And Kerala Land Reforms Act were placed in the 9th schedule. One victim of this law was a young head of a mutt at Kasargod district in Kerala. His name was Keshavananda Bharti, a young 22-year-old mutt. He was also the owner of various sugar factories in Kerala, which would have got impacted because of this Kerala Land Reforms Act. And he approached the Supreme Court. Since he was the first one to approach the court, the case came to be known as Keshavananda Bharti versus State of Kerala. But in this case, all other cases were added. Those who challenged privy purse abolition, these also got clubbed under this case. Those who challenged Article 31C, those also got added to this case. Various cases got added. And the fundamental question in all these cases was the same. Is the power of Parliament supreme that it can amend any provision of the Constitution? Tomorrow at 6 o'clock, we will discuss how this case was fought. What did the Supreme Court rule? What is this doctrine of basic structure? How Constitution can really be amended? And how Keshavananda Bharti, despite losing his own case, Indian democracy won. Because Keshavananda Bharti, in fact, lost his case. But Indian democracy won. How? We'll meet tomorrow, 6 o'clock.